Hi everyone, and thank you for joining me for May 2019 My PIP Monthly. My name is Javon David, and I'm a partner at Secrest Wardle's Troy location. We do these PIP Monthlies each month to provide you with the latest information as to PIP law in Michigan, providing you with updated case law and also discussion on trending topics in PIP litigation. So this month, there are a couple of cases that are noteworthy from the Court of Appeals. Many of the Court of Appeals cases dealt primarily with bodily injury law. There really wasn't anything too significant in terms of PIP, but I picked the two cases that I think would have the greatest impact on claim handling and in litigated cases. The first case we'll discuss is Bates versus Auto Club Insurance, and the second case is Estate of Calvin Simmons. As for trending topics in PIP litigation, we'll talk about the assigned claims plan, notice of claims reimbursement, and the overall statute of limitations and its interplay in MAIPF claims. We've gotten several questions about MAIPF cases and decided it might be helpful to the general group of you out there listening to have a reminder or an overview as to the proper notice of claims when the placement facility or the MACP is involved. Of course, we can't let this month pass without talking about the historic Nofault Reform that passed the House and the Senate at the end of this month. There are key changes that are coming down from the legislature this month, primarily pertaining to attendant care, medical expenses, and coverage for insurance carriers. The Nofault Reform was created essentially to reduce premiums for individuals in Michigan. That was the hot topic that resulted in all of this coming to where we are at now. And just quick background here, in terms of attendant care, people who still receive unlimited benefits would be limited to attendant care of 56 hours per week for family and friends. As for the medical expenses, the legislature is essentially trying to implement some sort of fee schedule by allowing medical providers to charge only 200 to 250% of what Medicare reimburses for the same amount of treatment. And finally, the other key issue that came down from the legislature is the optional levels of coverage, ranging from individuals allowing to keep their unlimited coverage, but they'll essentially have 5 options for personal injury protection cover that carry savings on that portion of their insurance bill for up to 10%. And primarily the people that are going to likely get the greatest benefit out of this are senior citizens or individuals who have Medicare who can totally opt out of PIP coverage. So there will be various levels of coverage to choose from and no mandatory purchasing of insurance that provides unlimited medical expenses. Now, I am not going to go through every detail of the legislation here just because it truly is something that requires a complete discussion, and we've taken care of that by having Secrest Wardle issue their complimentary webinar series on the new law entitled Sweeping Changes to the No-Fault Act, a discussion on impact to insurers. This is presented by Nate Edmonds, senior partner, and Renee Townsend, an executive partner, both in our Troy office. Please visit Secrest Wardle's website for the webinar there. You can listen to it at any time, and you can also listen to it on iTunes as well. So they will provide a complete discussion. They'll talk about the impact to insurers. If you have any questions, you can contact me, Nate, Renee, or anyone else in our office to kind of discuss the changes and how it affects your claims. Now for the case law update, the first case we have is Bates versus Auto Club Group, which was an unpublished opinion. But essentially the Court of Appeals addresses the proper procedure for ensuring assignment of rights to claims and whether or not they are admissible, and broke down the ultimate proper procedure as including an amendment of the pleadings and providing the actual assignment itself. A promise of an assignment is not enough, as was the case in this particular matter. So in Bates versus Auto Club, the plaintiff moved to intervene into the primary plaintiff case, alleging that it incurred expenses in relation to treatment rendered to the claimant Bates arising out of a motor vehicle accident. The trial court did permit the intervention, and ultimately a jury awarded the intervening plaintiff $100,000 in expenses for treating the claimant. Ultimately, the intervening provider moved for entry of judgment, and Auto Club objected, stating that based on Covenant versus State Farm, the intervening provider had no standing to bring an independent cause of action in the first place, And further, there was no assignment at the time of the petition for intervention. Auto Club then contended that while the claimant and the intervening provider may have intended an assignment, that was simply insufficient under covenant. When the defendant moved for its motion for summary disposition, the intervening provider did eventually produce written assignments that were executed by the plaintiff and that had been stored in supposedly some garage due to a fire that the intervening provider had suffered. So they had a reason as to why this was not produced initially, but they then provided it when it was time for motion for summary disposition. The intervening provider argued that Auto Club never raised a standing defense as an initial matter, and therefore it was waived. This means that they never said that the intervening provider had no standing to sue. The second argument was that the recently discovered assignments unequivocally established that Bates assigned his rights to the intervening provider. The trial court ruled in favor of the provider, giving credence to the fact that not only had the parties been operating as though an assignment existed, but also the intervening provider ultimately produced a valid assignment, unlike the facts in covenant. So although the assignment was delayed, they ultimately did produce that. Now, the Court of Appeals disagreed with the trial court and vacated the trial court's judgment. They agreed with Auto Club that the intervening provider failed to state a claim upon which relief could be granted, and also held that the provider should be permitted to amend its complaint to pursue recovery under an assigned claim theory, as they now have the assignments from Bates. So although the Court of Appeals agreed with Auto Club that the promise of an assignment was insufficient and that they could not just rely on an alleged promise to pursue this kind of claim, the Court of Appeals did say that the intervening provider had an opportunity and the ability to amend its pleadings to thereafter pursue an action. So the takeaway from this, which doesn't come up too often in this time, because providers basically have it down to a system where they get these assignments at almost every treatment visit. But for those older kinds of claims that the claimant may not have assigned their rights at the treatment, or they're maybe no longer treating at this particular facility, you want to make sure that the provider is producing a valid assignment at the time that they file their suit or file the claim to intervene. And if they don't, then push back on it and force their hand, force them to produce the assignment, otherwise they cannot pursue a claim. As the court in Bates stated, a promise of an assignment is simply not enough to pursue an action. Now, the next case that we have this month is the estate of Calvin Simmons by Victor Payne, personal representative, versus Auto Club Insurance Group. This case is particularly important because it discusses unsworn statements that are submitted in a claim in support of the entirety of the claim, and whether or not those unsworn statements, such as records or documentation from providers, may survive a motion for summary disposition. Ultimately, the court in this case stated that the court rules allow a party to oppose summary disposition on the basis of documentary evidence, and per the Court of Appeals, a failure to produce affidavits or deposition testimony is not necessarily fatal to a non-moving party. They can submit those unsworn statements in support of their motion for summary disposition to either create a question of fact or find that the defendant isn't entitled to dismiss the case. So, just by way of background, in estate of Calvin Simmons, the plaintiff suffered a significant hip fracture in a motor vehicle accident in 2011. As a result of the injuries, the plaintiff required extensive hospitalization and treatment. At some point in December 2014, the defendant's doctor reviewed plaintiff's medical file and determined that a particular hospitalization pertaining to a heart attack was unrelated. As a result, defendant concluded that plaintiff no longer needed assisted living arrangements for injuries related to the accident, and they terminated the no-fault benefits effective January 2015. So essentially, they determined that the heart attack was the ongoing reason for the need to stay in a facility, and that the auto carrier would not be responsible for those kinds of treatment, which is correct. But ultimately, the plaintiff filed suit saying that the termination was improper, that the treatment was still related to the motor vehicle accident. Defendant thereafter moved for motion for summary disposition, arguing that the 2014 care was unrelated to the injuries from the motor vehicle accident. In support of its motion, defendant provided an affidavit from its doctor and his reports. In response, the plaintiff provided medical records, a case manager's progress report, and letters and reports from a doctor. The plaintiff did not attach any sworn statements like the defendant did, and did not have any kind of deposition testimony or anything like that to support their response in opposition to the motion for summary. So the court ultimately granted defendant's motion, ruling that plaintiff was relying on inadmissible unsworn statements and letters in support of their position, and therefore the defendant was entitled to dismissing the case. However, the Court of Appeals reviewed the entire record and concluded that the trial court got it wrong. They essentially did not agree that failure to provide sworn statements is insufficient to survive a motion for summary disposition. The court particularly relied on the Michigan Court Rule 2.116 G6, which allows a party to oppose a summary disposition motion on the basis of documentary evidence, and therefore a failure to produce affidavits or deposition testimony is not fatal to a non-moving party. Essentially, the court ruled that it does not matter if the documentary evidence itself is admissible. As plaintiff provided substantial documentary evidence, such as the case manager reports, the letters from the doctors, and the medical records themselves, then the court should have taken that information and used it as part of its ruling and finding in favor of the plaintiff. So the court overturned that particular part of the claim. However, while disagreeing with the trial court's reasoning, the court affirmed the decision to grant summary disposition because the plaintiff failed to submit records regarding his post-2014 care. Therefore, these records failed to establish a genuine issue of material fact regarding the medical expenses incurred after 2014, and the grant of summary disposition was proper. But the key point of this particular case is that it's not proper to argue that an individual needs to provide sworn statements, deposition testimony, or some sort of affidavit to survive a motion for summary disposition. As evident by the documents provided here, medical records, case management reports, all can support an argument in opposition to a motion for summary disposition, and likewise, you can use them in the motion itself as well. Obviously, if you have sworn statements, if you have the affidavit, that's going to bolster your position. And if you have deposition testimony, you're going to want to get all of those things before the court so that you can strengthen your position. But a failure to include these things does not mean that you are either entitled or not entitled to a dispositive motion ruling. Now, as for the trending topics in PIP litigation, I defer to my esteemed colleagues Nate Edmonds and Renee Townsend to provide you with a complete overview of the Michigan Nofault Act changes in their webinar series that was launched yesterday. Now, I'll talk about the Notice of Claim and the MAIPF, or the Michigan Assigned Claims Plan. As I stated, we've gotten some questions about notice of a claim to the assigned claims carrier from in-state and out-of-state carriers, and believe that it's always nice to have the refresher as to when notice is proper and how the MAIPF becomes involved. So, of course, generally under the No-Fault Act, notice of loss is governed by MCL 500.3141, which is the notice of loss, and it specifies what is required for notice of loss. In addition, MCL 500.3145 is the statute of limitations, as we all know, as the 1-year back rule, which states that a claim must be submitted or suit must be filed within 1 year of the motor vehicle accident. Now, it's a bit different when the assigned claims carrier becomes involved. And for those of you listening from out-of-state carriers, the assigned claims plan is the carrier of last resort. And essentially, it's governed by MCL 500.3174, and it creates a system to ensure that individuals are covered in instances when there's no potentially unavailable insurer. Now, under this provision of the No-Fault Act, all self-insurers and insurers writing insurance in Michigan must participate in the MACP, which is under the full name of the Michigan Automobile Insurance Placement Facility. Pursuant to this provision, an individual, resident or non-resident, is entitled to benefits under the No-Fault Act because of accidentally bodily injury arising out of the ownership, operation, maintenance, or use of a motor vehicle, but there are some limitations. If the accident occurred in the state, no-fault wage and medical expenses are recoverable from the MACP if no other higher priority of no-fault sources are available. In addition, the MAIPF becomes involved if there is no other no-fault insurer higher priority. No PIP can be applicable to the injury. The PIP carrier cannot be ascertained due to a dispute among carriers, or the only identifiable carrier in priority is inadequate. That last provision often comes into play when there is a dissolved insurance entity involved. But essentially, the claimant has to exhaust all other options for PIP coverage before going to the MACP for coverage, but it's always going to be an option there. Now, as to notice of the provision, this particular claim is governed by 3174, which governs notice for MAIPF claims. And under the Michigan No-Fault Act, a claimant must notify the facility of his or her claim within the time that would have been allowed for filing an action for PIP benefits if identical coverage is applicable to the claim had been in effect. So, although the language is similar to 3145, the claimant must file a lawsuit within 30 days of notification of the assigned claims carrier or within the time period allowed for bringing suit against an insurer, whichever is later. Now, the MACP has its own duties. It must promptly assign the claim and notify the claimant of the identity and address of the insurer to which the claim is assigned. So once the MACP receives notice that there's been an accident, they have to assign the claim to a carrier such as Allstate or Progressive or someone along those lines and notify the claimant as to who is going to be handling their claim. Now, after that claimant receives notice, they have to file a lawsuit within 30 days of notification or within the time period allowed for bringing suit against insurer, which is a year, whichever one is later. So in short, a PIP suit is timely filed with MACP claims if filed 1 year after an accident or within 30 days after notification of the assigned claims carrier, whichever date is later. Now, oftentimes from the defense perspective, we are less often dealing with whether or not the claimant submitted the claim timely, but more often dealing with whether or not the assigned claims carrier provided sufficient notice or sufficient time to obtain reimbursement from a proper carrier. So, for example, let's say it was initially determined that there was no applicable PIP coverage. The MACP then assigns that claim to a first-party carrier. However, down the line, it's discovered that the claimant does have PIP coverage through another carrier, and that carrier is higher in priority. If the MACP carrier then goes after the proper carrier, they're going to need to do so in a proper procedural manner and in a specific time frame pursuant to the Michigan No-Fault Act. And that's where we come in. Typically, on the defense side, it's whether or not the assigned claims carrier did provide sufficient notice, and it's usually the dispute among insurers that probably comes across your desk as a claims adjuster or when you're dealing with counsel on your cases. Now, an assigned claims carrier has a longer limitation period than a claimant to seek indemnity or reimbursement from a third party. The assigned claims carrier must bring an action within 2 years after the carrier assignment or within 1 year after the date of the last payment to the claimant, whichever date is later. And that language is specifically written into the No-Fault Act. It's 500-3175 subsection 3. And the leading case that is often relied upon in this is Spencer versus Citizens. In Spencer, the party receiving benefits through the assigned claims program was a pedestrian injured by a hit-and-run driver. Because the plaintiff was uninsured and did not reside with an insured person, the assigned claims facility, or the MACP, assigned the plaintiff's claim to Citizens. Later, apparently after the 1 year limitation period, plaintiff discovered the identity of the hit-and-run driver and obtained a third-party recovery from the driver's insurer. Citizens, the assigned claims insurer, argued that because a higher priority insurer was discovered, it was excused from its obligation to pay on this particular claim. Plaintiff took the position that defendant was responsible under the statute for providing benefits, but could seek reimbursement from the other insurer. Ultimately, the Court of Appeals determined that the discovery of the higher priority insurer after the limitation period passed really had no bearing on plaintiff's right to timely benefits from the assigned claims carrier. Instead, the insurer was not relieved of its obligations to the injured party simply because another insurer became known, and defendant's termination of benefits also contravened public policy. Now, so basically, you can't just stop paying if you're an assigned claims carrier because you find another carrier higher in priority. What you must do is pay on the claim and then seek reimbursement from the higher priority carrier. But you also must do so in a timely manner and give notice in a timely manner as well. As stated, the action has to be commenced within 2 years after the carrier assignment or within 1 year after the date of the last payment to the claimant, whichever date is later. So those are the key issues as to notice of assigned claims cases and when insurers become involved due to reimbursement from assigned claims carriers. If you have any questions on this particular issue or any of the case law that we discussed here today, please contact me or senior partner Mark Masters to get additional information. Our contact information is listed on the last slide of this month's My PIP Monthly. Thank you so much for tuning in, and we look forward to seeing you next month.